In the year 2012, when I was arrested for willful failure to file federal income taxes, I was taken to a second judge on a particular occasion because the presiding judge was not available. And this judge, as I stood there shackled around the waist and the ankles and the arms, proceeded to treat me indignantly compared to the assistant United States attorney. It was so gross a violation that at one point I looked at the judge and I said, "Your Honor, would you mind giving me the same consideration that you're giving the United States attorney?" The judge looked at me, and without saying a word, he nodded. And had I known any better at the time, I would have said, "Let the record show that the judge is going to change his temperament and give the defendant the same respect in this courtroom that he's giving the United States government." Now, this video is for May 7th, 2026. Welcome to YesToHellWith.com. Today we're going to discuss something that most people never think about until they are standing in a courtroom under pressure. How do you slow the process down when the judge is moving too quickly or has a bad temperament? Now, understand this carefully. The courtroom operates on momentum. Cases are called rapidly. People are expected to respond immediately. The judge controls the pace, and most defendants become overwhelmed before they ever regain their composure. This is especially true for pro-per defendants, because the environment itself creates pressure. The judge, the prosecutor, the deputies, the procedure, the courtroom itself. And under pressure, people panic. They begin reacting emotionally. They begin agreeing to things they do not fully understand. And they begin losing control of themselves. So today we're going to discuss some realistic ways to slow the process down without becoming combative or disrespectful. Now, understand the goal is not to beat the court or beat the judge. The goal is not endless argument. And the goal is certainly not hostility toward the court. The goal is to create enough space for clarity. That is the purpose. One of the first things a pro-per defendant should understand is that courts recognize, at least in principle, that a self-represented litigant does not possess the training of an attorney. This is why cases such as Haynes versus Kerner are often referenced, not because they magically solve problems, but because they acknowledge a basic reality. A pro-per defendant lacks formal legal training. And once that reality is acknowledged, the pace should change. The court should understand that the defendant may require clarification, patience, or reasonable procedural latitude in order to participate meaningfully. This does not mean the judge becomes your advocate, and it does not mean the court gives legal advice, but it does mean fairness requires restraint and patience. So one practical approach is to calmly remind the court of your pro-per status early in the proceeding. For example, "Your Honor, I respectfully ask the court to recognize that I'm appearing pro-per and do not possess the training or experience of licensed counsel. I ask for reasonable procedural latitude so that I may meaningfully participate and preserve my rights." Now notice the tone: calm, measured, respectful, no hostility, no accusation. Now another practical way to slow the process is ensuring that the record is preserved, because once everyone understands the record matters, the pace often becomes more deliberate. The judge knows the record matters. The prosecutor knows the record matters. It's being recorded. This is not manipulation. This is accountability. Now, there are also situations where the judge becomes impatient or aggressive. And when that happens, most people emotionally collapse. They are either submissive or combative, and both are mistakes. Instead, the proper response is calm restraint. For example, "Your Honor, I am attempting to proceed respectfully and carefully. I ask for patience so that I may properly understand and respond." Or, Your Honor, I do not intend disrespect. I am attempting to preserve clarity and avoid misunderstanding. Now, notice again, the goal is not confrontation. The goal is reducing pressure while preserving composure. Now, another important point involves judicial ethics and courtroom conduct. A calm reference to fairness and meaningful participation can sometimes encourage the court to moderate its tone without direct accusation. For example, Your Honor, I am attempting to participate meaningfully and respectfully in the proceeding, and I ask the court's patience as I do so. That statement subtly invokes fairness without openly attacking the judge. And psychologically, that matters, because many judges do not want the appearance of hostility toward a self-represented defendant preserved on the record. That's not good optics. Now, understand this carefully. None of these approaches are magical. None guarantee outcomes, and none place you in control of the courtroom. The judge still controls the courtroom, but what these approaches can do is slow momentum, reduce pressure, build confidence, preserve clarity, and help you maintain composure. And that matters far more than most people realize. Because once a person psychologically collapses in court, the rest of the proceeding usually becomes reaction. The Liberty Dialogues is not about magical phrases or courtroom theatrics. It's about structure, discipline, clarity, and maintaining composure under pressure. That is the lesson. And as always, may truth reign supreme. That is the lesson. And as always, may truth reign supreme.